Welcome to the final round of the largest ever international mock trial contest. We began with 48 teams. We are now down to the final two. And boy, do we have an esteemed judging panel for you all today. First, we have many-time outstanding judge winner, graduate of Grinnell, William Wu. William, what is your message to these teams?
Good luck, have fun. I know you guys are incredible, so I look forward to a great trial.
Next, we have person who has been around mock trial for the last 16 years because he is my father, Mr. Michael Lampert.
Hi, everybody. Do your best. I love watching mock trial, and you guys, I've seen some of you before. You guys are great. Good luck.
And of course, the co-founder, the driving spirit behind international mock trial, truly the godfather of Chinese mock trial, your presiding judge, the Honorable Max Wong.
Thank you so much, Ian. I know that many of you are veterans. Have fun, stay calm, and then really looking forward to this.
Best luck to both teams. Let's get this round started.
Excellent. We're going to start with housekeeping matters, and why don't we do appearances for the prosecution first?
Yes, Your Honor. Good evening, Your Honor. My name is Anya, and today alongside my co-counsel, Miss Vivian May.
Good evening, Your Honor.
Together, we represent the state of Tilly.
Thank you. Appearances for the defense?
Yes, Your Honor. Hello, Your Honor. My name is Christiana Garcia, and today I'm pleased to be joined with my friend and colleague, Elizabeth Liu.
Hello, Your Honor.
Good morning.
Your Honor, we also
Yes.
are joined by our legal intern today, Audrey Ma, who will be handling all the technical sides of trial.
Sounds good.
Good evening, Your Honor.
Let's go back to the prosecution for a second. Anything you want me to know, or any rules you want to invoke?
Yes, Your Honor. First, we'd like to invoke Rules 603 and 615, constructively swearing in and sequestering all witnesses, barring party representatives.
Do you have a party rep?
No, Your Honor.
All right. Ms. Garcia?
Yes, Your Honor. Investigator Nova Wölff.
All right. We'll invoke rules 603 and 615. Anything else, Ms. Law?
Yes, Your Honor. And next, we'd just like to ask your preferences on screen sharing. Would you like for us to state for the record or ask for permission each time?
Stating for the record is sufficient.
Yes, Your Honor. And finally, Your Honor, we'd just like to bring the court's attention to stipulation number 7, which lists that the following list of exhibits are pre-admitted: Exhibit 2, 10, and 12.
Sounds good.
With that, the government's ready to go.
Thank you. Ms. Garcia, anything from the defense?
Yes, Your Honor. First, we'd like to bring the court's attention to stipulation 11. It states that Nova Wölff is a private detective certified by the Tilly Detectives Association.
All right.
With that in mind, we'd actually like to bring the court's attention to a case law, Tilly v. Swift and Haim, 1989, which sets a precedent that licensed private detectives are not compelled to cease investigations when instructed by law enforcement, so long as those investigations independently do not violate the law.
Okay.
Lastly, Your Honor, we'd like to notify the court that during our meet and confer with opposing counsel, we offered the pertinent traits of just and law-abiding for Investigator Wölff under Rule 404A2A. And my co-counsel, Ms. Liu, will now be offering a written notice in the chat now.
All right. Prosecution, does that seem accurate?
Yes, Your Honor, but we do reserve the right to object when it comes up in trial.
Okay.
With that, Your Honor, we're ready to get this ball rolling.
Thank you so much to both sides. So opening statement from the prosecution, please.
Yes, Your Honor. May I proceed?
Please.
She kidnapped to catch a killer. It's March 11th, 2025, and the defendant, a woman named Nova Wölff, is lurking in the shadows. She's watching and she's waiting for the perfect opportunity to strike. And she's got it. Cotter Ashlock felt the hairs on the back of her neck stand up. Just moments, but before the defendant takes a swing at her, knocking her out cold. The defendant would then drag Miss Ashlock into her basement, tying her up and interrogating her. Why? For answers. Because the defendant believed that Miss Ashlock knew who killed the defendant's best friend. She's kidnapped to catch a killer. And that's why we today, as the prosecution, are charging the defendant with unlawful imprisonment and interfering with a police officer. And in doing so, we understand that we've taken upon a burden to prove beyond a reasonable doubt that the defendant kidnapped Cotter Ashlock and interfered with an ongoing police investigation. And while we understand that that's a high burden, it's not impossible to meet, because we're going to meet it today with two simple facts: the disregard and the detention. And so first, the disregard. You'll learn today that the defendant was a private investigator herself. That means that she works for herself, not the police department. But a detective will take that stand today and explain how the defendant repeatedly ignored his warnings and interfered with his investigation into the Ashlock crime family. This wasn't the defendant's case, but she was obsessed and relentless about it. Because this wasn't just a case to her. It was revenge against the family that killed her best friend. And so second, the detention. You'll hear today how Cotter Ashlock was a member of that very crime family. Miss Ashlock will take that stand today and tell you how her family killed the defendant's best friend. And ever since, the defendant was out for revenge. You'll learn that the defendant was stalking the Ashlock family, sending them emails and threats. She swore to Miss Ashlock, "I will tie you up and torture you until you beg me to kill you." And when she finally got her opportunity to capture Miss Ashlock for violating her parole, she didn't call the police right away. Instead, she captured her and kept her in the basement for nearly an hour, interrogating Miss Ashlock for information about her best friend's killer. Members of the jury, that's not a citizen's arrest. That's someone who broke the law for revenge, because she kidnapped to catch a killer. Members of the jury, we get it. Losing a friend to gang violence is one of the worst things in the world. But that isn't an excuse to capture and torture someone else. That's why, at the end of today's trial, my co-counsel, Ms. Anya will come before you again and ask you to reach the only just verdict. Find the defendant guilty. Thank you.
Thank you, Ms. May. Defense opening when ready, please.
Yes, Your Honor. She captured a criminal to stop a crime. An investigator named Cotter Ashlock is breaking her parole. She stands feet from the home of investigator Nova Wölff's house. She's not there by coincidence. She's there to commit a crime against the investigator who put her entire criminal family behind bars. Moments later, Investigator Wölff, she hears a disturbance outside. Unsuspectingly, she steps into the dark night. When suddenly, the criminal reaches into her jacket, pulls out a knife, and lunges to attack her. In that moment, Investigator Wölff has a choice: die or fight for her life. And today, you'll learn she exercises her lawful right to self-defense, disarming and detaining the criminal until the police came. Miss May is wrong. She didn't kidnap. She simply captured a criminal to stop a crime. And when the state chose to charge her with those 2 felonies, they chose to take on the highest burden in our legal system, called proof beyond a reasonable doubt. A moment ago, Miss May claimed this case is about disregarding and detention. But what she didn't tell you is the word defense. Self-defense. And that's important because we've brought forth an affirmative defense of a citizen's arrest. Now, I'll spare you years of law school. Simply put, we have to prove it's more likely than not she witnessed a crime, she used reasonable force in her capture, and she contacted the police within reasonable time. Now, as you see on screen, if we prove these 3 elements, you must find her not guilty. So, let's walk through each of them one at a time. First, the crime. Today, a resident from the neighborhood will tell you that she heard Miss Ashlock pull out a knife and try to kill Investigator Wölff. And unlike the state's claims, you'll see that the only evidence that supports that story isn't just Miss Wölff's statements. It's DNA evidence that shows that knife solely belonging to Miss Ashlock. So second, the capture. Because unlike Miss May told you, the law doesn't require a citizen to be involved in an investigation to act. You'll see that disarming the criminal, tying her up, and keeping her in their basement to prevent further crime was Miss Wölff simply exercising the right every citizen in this courtroom has to act reasonably in a situation of danger. So lastly, you'll learn when she contacted the police, it was within reasonable time. Members of the jury, you'll hear from Investigator Wölff today that once Cotter Ashlock stopped threatening her, she contacted the police at the first opportunity. Because today you'll learn she captured a criminal to stop a crime. The state told you this case is about revenge, and we agree, because the evidence will show you that Ashlock had the revenge. She had the need for motive, and she had a knife. Members of the jury, she acted on revenge. But Investigator Wölff, she acted out of self-defense. And today, as jurors, we'll ask you to act with the need of justice. And when you do, you'll find her not guilty, because she captured a criminal to stop a crime. I appreciate your time, folks.
Thank you for both openings. And my co-judges, will start the case in chiefs. Try to give me a thumbs up, unless you need more time with your ballots, please. Yeah, Michael, let me know when you're done, please. Okay. First witness from the government?
Yes, Your Honor. We call Larry Capolino to the stand. May I proceed?
Please.
Good evening, sir. Could you please introduce yourself to the court?
Yes, my name is Larry Capolino.
What do you do for a living?
I am a sworn officer with the Corleone Police Department, currently assigned to the Major Crimes Division.
Well, officer, how'd you get into this line of work?
I've wanted to protect people ever since I was a child. And now, as a father of two, I want to make sure my community is safe as a police officer.
How are you qualified for this position?
Well, I've served with the Corleone Police Department since 2011, and in that time I've been involved in over 50 felony cases involving organized crime and violence. My training includes advanced investigative techniques, evidence handling, and crisis negotiation.
So why are you here in court today?
I was the lead investigator in the case involving Cotter Ashlock's alleged imprisonment on March 11th, 2025.
Let's talk about the beginning of your investigation. Before that, who is Cotter Ashlock?
She is a member of the notorious Ashlock family, one of the biggest crime groups in the region.
Do you know if the defendant had any past history with the Ashlocks?
I've investigated their family for years, so I was aware that a former member of the Ashlock family poisoned one of her best friends. Since then, she has actively tracked them down.
Do you know if she went after Cotter Ashlock?
Objection, Your Honor. Under Rule 404, improper character evidence, if I may be heard.
Go ahead.
Your Honor, Officer Capolino just testified that Investigator Wölff had been repeatedly or consistently tracking them down. We believe this is using a prior act to prove action in conformity therewith, which is textbook character evidence.
A response?
Your Honor, we're actually offering this under Rule 404b2 under motive, and this establishes that the defendant has very bad past history with the Ashlocks, which is why she is tracking them down.
Response, Your Honor?
Yes.
Your Honor, under Rule 404b2, the prosecution in a criminal case must provide written notice to such intent prior to witness selection during meet and confer. Unfortunately, Your Honor, as the defense, we never got any sort of notice on the prosecution's part.
Response.
There has to be Yes, please.
Your Honor, we are not offering this as character evidence at all. It's not our intent, or nor the witness's testimony to make this 404. Instead, we are offering this solely for motive, which does happen to fall under the exception 404b2.
If I may clarify, Your Honor?
Yes. And please clarify for me where it states that the prosecution has to offer this ahead of time.
Yes, Your Honor. Under Rule 404b2, as Ms. Lowe just cited, it says permitted uses notice in a criminal case. The prosecution may be introducing character evidence for a purpose such as motive, as Ms. Lowe mentioned, but that comes with the prerequisite that they provide written notice of such intent prior to witness selection. Your Honor, that's our understanding of the rule for character evidence under this jurisdiction, and specifically, that pertains to 404b2 as well.
A brief response, Ms. Lowe?
Your Honor, that's not our understanding, because for the purposes of today's trial, we do not have any intent to be using this as character evidence, which is why we don't need to provide notice, because we're offering this simply for motive, nothing about the character of the defendant.
Last response, Your Honor.
No, thank you. It's far argued. Objections overruled.
Yes, Your Honor.
So, officer, do you know if the defendant went after Cotter Ashlock?
I was worried she might. So on March 6th, when Cotter Ashlock was released on parole the previous week, I called Wölff to warn them not to involve herself.
Well, did the defendant involve herself with Cotter Ashlock?
Yes. Just a few days later, on March 11th, at 11:35 p.m., the police received a call from Nova Wölff saying that she had restrained Cotter Ashlock.
Would you recognize a copy of that transcript if I showed it to you today?
I would.
Your Honor, for the record, the state is now screen sharing Exhibit 4C. Officer, what is this?
This is the phone record of Nova Wölff's call.
Does it look fair and accurate?
It does.
Is it me or
moves to
I don't? Sorry, I think my screen might be frozen. I don't.
I see it on my end, Your Honor, but we can wait a moment and see if it gets up on yours. All right, officer, one more time for the record. Does this look fair and accurate?
It does.
The state moves to enter Exhibit 4C.
Any objections?
No objections to 4C, Your Honor.
All right, 4C is received.
Officer, looking at this exhibit, why did the defendant detain Cotter Ashlock?
Looking at this, Cotter Ashlock was trespassing on her property. So I gathered a few officers as soon as possible and drove with them to Wölff's home.
What did you discover there?
Cotter Ashlock was in the defendant's basement. She was bruised, disheveled, and sitting on a chair.
Did you find anything else?
Yes, in the basement we discovered rope fragments, a damaged chair with red residue, and a phone believed to be Ashlock's. We also recovered a kitchen knife from the counter adjacent to the entry point to the basement.
Let's talk about if the defendant kidnapped to catch a killer. Because do you know Cotter Ashlock's side of the story?
I do. She said that she was abducted while walking through Corleone town. She was struck from behind, tied to a chair in a dark basement, and interrogated by Nova Wölff. This did not match the defendant's story.
Well, what was Cotter Ashlock interrogated about?
Well, Wölff demanded to know the location of Jay Kuang and threatened Ashlock with a knife, in addition to smashing her phone.
Does this match the evidence you found?
Yes. Beside the rope fragments, we did find a smashed phone, a knife, and a transcript of some of their interactions in the basement.
Would you recognize a copy of a transcript of their interactions?
I would.
Your Honor, for the record, the state is now screen sharing pre-admitted Exhibit 2 pursuant to stipulation number 7.
Okay.
Officer, what does this transcript tell you?
It was clear Ashlock was restrained and tied up. She said, "I want you to untie me before I spill a word."
Could you determine anything else?
It also says, "I recommend you start talking to me, or you can talk to the police." This matches Ashlock's story about the interrogation.
And in this transcript, did the defendant mention calling the police immediately after restraining Ashlock?
No. Instead, she waited. She kept asking Ashlock to talk.
Well, finally, let's talk about when the police got involved. Because, officer, was there an active police investigation into Cotter Ashlock?
There was.
Was the defendant on this case?
She was not. In fact, I asked her to not get involved. While I understand private detectives do have more leeway, that doesn't allow them to break the law in their investigations, and unlawful imprisonment would be breaking the law.
Can you tell us what a citizen's arrest looks like?
If a citizen sees someone committing a felony, they may detain them, but then they must immediately call the police.
And if someone unlawfully restrained another involved in your investigation, would that be interfering with the police?
Yes, if there was an unlawful kidnapping of our suspect, that would be directly going against the law and law enforcement.
And would it matter if they captured a criminal to stop a crime?
If the arrest is unlawful, no, intent would not matter.
Thank you, officer, for your time today. Your Honor, we have nothing further.
Cross.
Yes, Your Honor, but prior to cross, if I could sort out an issue with the 404 objection to clarify something for the record.
Regarding the previous objection?
Yes, Your Honor, we actually looked back at the rules of
No.
evidence under. Yes, Your Honor. Tech, we can get that down. Your Honor, may I
But
proceed?
I understand the issue. Thank you for bringing that up.
Yes, Your Honor. Hello, Officer Capolino.
Hello.
A moment ago, you told us Investigator Wolf's actions, they don't qualify as a citizen's arrest. That's what you said, right?
It is.
Because she didn't call the police immediately?
That's right.
Officer, I'm looking for a number here. How many minutes does the law require someone to call the police by?
It doesn't say, but if I remember, it says that you should do it as soon as possible.
Sir, as soon as possible. That isn't the same thing as immediately, is it?
Yes, but I believe that Nova Wölff waited possibly over an hour. This clearly is not as soon as possible.
Well, sir, you'd agree with me. The law calls for something called reasonable, right?
Yes,
You'd agree with me that if someone was actively being threatened with a knife, it'd be unreasonable for them to require to call the police right then and there.
I'm sorry, I don't understand your question.
No worries, officer. You would agree with me that if someone was actively being threatened with a knife, they don't need to immediately call the police at that time. Yes or no?
The person being threatened with the knife wouldn't need to call the police?
Correct, sir?
If they're being threatened, they would not need to call, but once the threat has stopped, they would need to call the police.
Sir, you'd agree with me Investigator Wolf was being threatened with a knife that night.
At one point, yes.
And as you said a moment ago, sir, you're the lead investigator in today's case, right?
I am.
Let's talk about whether or not your investigation ignored the signs pointing to Cotter Ashlock. A moment ago, you told us his words are backed by evidence.
They are, yes.
Is that your sworn testimony today?
It is.
All right, sir. Well, let's walk down that evidence, starting with what Cotter Ashlock told you. A moment ago, you told us she was struck in the back of the head, right?
That's right.
So hard she blacked out.
Yes.
But sir, you actually ordered a physical examination of Cotter Ashlock, yes or no?
I did.
You'd recognize a report of that examination now.
I would.
Stating for the record, Your Honor, we'll be screen sharing Exhibit 9.
Okay.
My apologies, Your Honor. It appears we're experiencing some technical difficulties.
No worries at all. Take your time.
Sir, this is that medical report, right?
It is, yes.
Seems fair and accurate.
Looks like it.
Your Honor, at this time, we move to enter Exhibit 9.
Any objections to Exhibit 9?
No objections, Your Honor.
All right, 9's received.
Yes, Your Honor. Sir, let's get this clear. Cotter Ashlock told you she was hit in the head so hard she blacked out, right?
That is right.
Right there it says, no contusions to the head were found.
Yes, that is what it said. I found it strange that it contradicted not only Ashlock's statements, but also my observed bruises all over Ashlock's body.
Well, sir, you say you found it interesting that it conflicted. Truth is, there's nothing in this medical report that makes you think it's not true, right?
That there were no contusions on the head?
Sir, I'm asking you about the authenticity of this document. There is nothing in your investigation you found that would make you think it's untrue, correct?
I believe it's an authentic document, yes.
All right, sir, and this authentic document says, this conflicts with the patient's claim of being hit on the head.
And that's what it says, yes.
And so taking a step back, sir, looking at this medical report, nothing indicates Cotter Ashlock was tortured that night, does it?
I don't believe that she was tortured. But
You
yes.
also don't believe she was physically assaulted.
She was definitely physically assaulted. I saw bruises all over her body.
Well, sir, nowhere in this report does it ever mention bruises all over her body, correct?
Yes, I find it strange that it doesn't.
But, sir, what it does mention is contusions to the right knuckle.
It does mention that.
These contusions could indicate punching someone. That's what that report says.
They could, yes.
But, officer, you never asked why those bruises were there, did you?
On the knuckle or on the body?
Sir, you never asked whether or not Cotter Ashlock punched someone with his knuckles, right?
I did not, yes.
You can't tell us whether or not she punched Investigator Wölff.
Not for 100%.
You disregarded those signs of assault, correct?
I did not.
Sir, it's your sworn testimony you didn't disregard those signs of assault?
I looked at that evidence, compared it to other evidence I found, and I believe that the evidence of unlawful imprisonment outweighed this report.
We'll let the jury decide that, sir. But for right now, let's move on and talk about another thing that you might have gotten wrong in today's case. A moment ago, you talked to us about some rope fragments, right?
Yes,
Talk to us about some physical evidence.
I did.
But sir, Miss Luo never showed us any forensic report, right?
I don't believe so.
I want to show that report to the members of the jury now, and we can walk through why she chose not to show that report. Stating for the record, Exhibit 11's on screen. Sir, that's the forensic report you reviewed, right?
It is, yes,
Seems fair and accurate.
it does.
You were the one who told the department to make this report, yes?
I did.
You know that making forensic reports, that's a regular activity of your department.
Sometimes. Depends on the investigation.
Sir, are you saying it's not a regular activity to make a forensic report?
It depends on the investigation.
All right, sir. Well, if you look on screen, there's a case number, right?
Yes,
Your Honor, at this time, we move to enter Exhibit 11.
Any objections?
Yes, Your Honor. Hearsay.
All right, response.
Yes, Your Honor, we believe we met all prongs of 8036, records of a regularly conducted activity. Would Your Honor like me to walk through those prongs?
That's fine.
Response, Your Honor.
Yes. What's your response to this? Is not a business record, please.
Your Honor, we right now have issues with 8036A and 8036C. Specifically under Rule 8036A, it has not been established yet the timeline of this record, that it was made at or near the time the information was transmitted. That foundation is missing, as well as under 8036C, that making the record was a regular practice of the activity. As Officer Capolino just testified, it's not necessary that every single case results in creating a forensic report, so it doesn't fulfill these prongs.
Response, Your Honor?
Ms. Liu? Yes, please.
Your Honor, before that, actually, can we get the exhibit back on screen, please? Yes, Your Honor. Under prong A, as we can see, this record was made on March 11th of 2025. As this witness
March
testified.
12th?
My apologies, Your Honor.
March 12th.
Yes, Your Honor. And as this witness testified to, the events of Cotter Ashlock's detainment, it happened on March 11th, which means that satisfies that this record was made at or near the time of the information transmitted. And as for prong C, Your Honor, as this witness agreed to, there's a case number, and we have a good faith basis to believe that we don't need to prove a forensic report is necessary in every single case. But as that case number suggests, the CPD consistently creates these reports, which satisfies prong C. There's a case number, Your Honor. It shows that it's a consistent, regularly conducted activity.
All right. Brief response from the government, please.
Yes, Your Honor. In terms of 8036C, in that case, we do need to have the witness talk about and interpret this case number and see what it possibly can mean. And not just Attorney Liu can't just be telling us what CPD forensic case number means and how that can refer to being a regularly conducted activity. That foundation has not been laid by the witness. What we have heard, though, is it is not necessarily every single case that results in a forensic report. And Your Honor, as for 8036A, we believe it hasn't been timely enough for the witness to establish that, yes, this date we found this evidence, and then right after this was within the proper time range to make the record.
Response, Your Honor?
Briefly.
Your Honor, once again, this witness testified on direct examination that on March 11th, he witnessed the events of this case. He collected the physical evidence. Surely, Your Honor, within
I'm fine with prong A. I think you've established that. If you could just give a quick argument about C again, please.
Of course, Your Honor. Your Honor, under Rule 8036, we don't need to have this witness spell out every single prong of this rule verbatim. Rather, Your Honor, it doesn't even mandate for this record to be every single time. It just needs to be a regularly conducted activity. And as this witness testified—
So, Ms. Liu, since the witness has testified that he said something along the lines that sometimes they make it, sometimes they don't. So, what kind of standard should I use here for prong C?
Your Honor, we believe that under Rule 8036C, unlike Ms. Luo mentions, it doesn't need to be every single case, but rather, Your Honor, it needs to be regularly conducted. As that case number suggests, there obviously is a line or a chain of production in which these records are made. And Your Honor, we believe the standard it should be held to is that it is a regularly conducted activity. There's a case number. It suggests that it's regularly conducted, as this witness mentions, when necessary.
All right. Thank you for the arguments. They're both well argued. I'm going to overrule the objection and we'll receive Exhibit 11.
Yes, Your Honor.
Yes, Your Honor. Sir, this report looked at fingerprints, right?
It does, yes.
Sir, how many fingerprints of Nova Wölff are on this report?
I believe 0.
0 on the knife as well, right, sir?
Yes.
Let's get this clear, sir. That's the knife Cotter Ashlock claimed she was being threatened with, right?
Yes, it contradicted that evidence.
Exactly, sir. Because the only fingerprints ever found were of Cotter Ashlock.
Yes, which is strange because why would Cotter Ashlock smash her own phone that's recording an active imprisonment?
Sir, you keep saying the words, "it's strange." Truth is, your investigation can't tell the members of the jury why those strange things happened, right?
Yes, I cannot.
You can't tell us why Cotter Ashlock's story just keeps contradicting itself.
Yes, Cotter Ashlock's story does contradict itself. I found to a lesser degree than of Nova Wölff's.
Sir, you keep talking about Nova Wölff's words. I want to move on to Nova Wölff's actions. It's true that a week before Cotter Ashlock was captured, you received a call, right?
I did, yes.
A call that Cotter Ashlock broke parole.
That's right.
And for a week straight, your department just couldn't figure out where this criminal was.
That is right, yes.
But sir, Investigator Wolf, she was the one who turned that criminal into the police.
Yes. However, even if your intent is altruistic, you can't break the law.
Sir, I'm not asking about intent right now. I'm asking about her actions. Yes or no? Investigator Wolf turned that criminal into the police.
By breaking the law, yes.
Thank you, sir. No further questions.
Thank you, Ms. Liu. Is there a redirect?
Yes, Your Honor. Officer, I want to spend some more time on the medical records that you were asked a lot about just by Miss Liu. Sir, did you notice any bruises on Cotter Ashlock's body?
Yes. When I entered the basement, there were bruises all over Cotter Ashlock's body. It's very strange and inconsistent that none of them are mentioned in this report.
So in that medical report, were any mentions of all those bruises found?
There were none.
Thank you, officer. Your Honor, we have nothing further.
Is there a recross based on that?
Yes, Your Honor, briefly. Officer Capolino, it sounds like a moment ago you said that report wasn't completely accurate.
Yes, it contradicted the bruises I found.
I want to make this clear, sir. It was you who told Cotter Ashlock to go get that report done, right?
That is right, yes.
So the report you ordered in your investigation, that's the report we can't trust today?
I did not make the report.
You ordered that report, right, sir?
I asked for it to be conducted.
The report you asked to be conducted, you're saying is unreliable.
Yes, just because I asked for it to happen doesn't mean that it's truthful.
Thank you, Officer Capolino, but we'll let the jury decide that. No further questions.
All right. Thank you. The witness may be excused. Next witness, please.
Yes, Your Honor. We call Miss Cotter Ashlock to the stand. Your Honor, may I proceed?
Yes, please.
Yes, Your Honor. Good evening, ma'am. Could you please introduce yourself to the court?
Good evening. The name is Cotter Ashlock.
What do you do for a living?
Right now, I'm actually in school. I'm studying to become a guidance counselor for ex-convicts. I want to help people like me change for the better.
And why did you want to get into that line of work?
I spent some time in prison because I used to work with my family's gang. I don't want anything to do with my past. I really don't. But I think it's important to talk about it. I want to help people like me do that.
So, Miss Ashlock, why are you in court today?
Ma'am, Nova Wölff kidnapped. And I'm here to tell you what really happened.
How do you know the defendant?
I don't know her personally, but our family killed her best friend. My cousin was the one to do it.
So what happened after your cousin killed the defendant's best friend?
Nova started following us. At first it was harmless, but eventually she escalated.
How'd she escalate?
Started leaving us threats. One time I remember receiving a package with a bloody blade in it, and there was a note attached to it. Sometimes it was a note, sometimes an email.
And would you recognize an email if I showed it to you today?
I would.
Your Honor, let the record reflect. We're going to be screen sharing what has been pre-marked as Exhibit 12B. Ma'am, looking at what's on screen, what is this?
This is an email that Nova Wölff sent me.
Does it look fair and accurate?
It does.
Your Honor, at this point, let the record reflect that Exhibit 12B is already in evidence pursuant to Stipulation 7.
Okay.
Ms. Ashlock, what does this email say?
It says, I will hunt you down to the ends of the earth if it's the last thing I do.
Did the defendant mention anything else in this email?
Yeah. When I responded, she told me, if I ever get my hands on any one of you, I will tie you up and torture you until you beg me to kill them.
So, Ms. Ashlock, how did you know that it was the defendant who sent this email?
Well, it was signed, the best friend of the man you murdered in cold blood. That's Nova. And when I called her Nova, she responded.
I want to turn your attention to the events of March 11th, the day of the crime. What were you doing that day?
I was looking for my cousin, the one who murdered Nova's best friend. For some reason, I thought he'd be in Corleone, and I wanted to go see him, but I couldn't find him.
What happened after you couldn't find your cousin?
On my way back home, Nova just came out of nowhere. I mean, one moment I was walking home, and the next thing I know, she's behind me, and something hit my head. Everything went black after that.
Miss Ashlock, what happened when you woke up?
I was tied to a chair, and there was a piece of duct tape over my mouth. It was cold and dark, and I looked up and I saw Nova standing over me.
Did the defendant do anything?
She started asking me questions about someone named Jay Kuang. Jay Kuang who killed her best friend. She wanted to know everything about him, but I didn't know a Jay Kuang.
So, ma'am, looking back, how did your kidnapping affect you?
Ma'am, I was in this business for a long time.
And as to relevance,
Response?
Yes, Your Honor, we're simply using this for the credibility of this witness. And moreover, Your Honor, relevance has an extremely low bar, and seeing that we're exploring the impact on Ms. Ashlock's life, it's extremely relevant.
Your Honor, may I be heard?
Yes.
Your Honor, this is a criminal case, not a civil case. The state has no burden to prove any sort of injuries or any sort of damages in this case. So asking how it affected her is irrelevant to today's matters.
So, how exactly would how it affected Miss Ashlock make any fact in this case more or less likely?
And Your Honor, we're simply using this line of questioning to explore the witness's credibility, given that, if I may proffer, Your Honor?
You may.
In a moment, we expect opposing counsel to ask a line of questioning that could damage this witness's credibility. By exploring this line of questioning, it simply establishes her line of events and furthers her testimony.
Your Honor,
All right,
maybe.
Miss Garcia. No, I'll allow it, but Miss May, you're on a pretty short leash, please.
Yes, Your
Yes,
Honor.
Your Honor, understood. Ms. Ashlock, I'm going to ask my question one more time. How did your kidnapping affect you?
Ma'am, like I said, I was in this business for a long time. I've seen guns, seen poisons, I've seen violence, and I've even seen death. But I've never been helpless. Being tied to that chair in Nova's basement felt helpless.
Thank you for your time today, Ms. Ashlock. Your Honor, at this point, I have no further questions.
Cross-exam?
Yes, Your Honor. Hello, ma'am.
Hello.
A moment ago, you told us you were trying to be a guidance counselor.
I am, ma'am.
I want to guide the members of the jury through what these prosecutors might have not done. When you spoke to investigators and prosecutors in this case, they never asked you whether or not you attacked Investigator Wölff with a knife, did they?
No, ma'am, but I would not do that.
They never asked if you try to physically assault Investigator Wölff.
No, ma'am, but I wouldn't do that.
Ma'am, you're saying on stand you wouldn't do that. But let's see if there's any inconsistencies pointing to you committing a crime. Stating for the record, we'll now be screen sharing Exhibit 9, which is a medical report of Mrs. Ashlock's. Ma'am, a moment ago you claimed that you were attacked by Investigator Wölff.
Yes, I was hit over the head.
Exactly, you said you were hit over the head.
Yes,
Ma'am,
ma'am.
that's your sworn testimony today in court?
Yes, ma'am.
But right here, the medical report says no contusions to the head were found.
Objection, Your Honor, outside the scope of knowledge.
Response?
Your Honor, this is a medical report that was examined from her specific medical examination. She would have knowledge, and if she doesn't, she can simply say she doesn't know.
Response?
Yeah, Exhibit 9's already in evidence. If the witness is unfamiliar with it, she could respond.
Yes, Your Honor.
Now, ma'am, right there it says no contusions to the head were found.
That's what it says, but I haven't seen this document before.
All right, ma'am. Well, that means investigators and prosecutors never asked you about this medical report.
No, ma'am.
They never asked if anything on this medical report was contradicting to what you were saying.
They didn't, ma'am. But I will tell you that I was hit on the head.
Okay, ma'am. Well, you know what else this medical report says? It says that there was a contusion to your right knuckle.
Did I hear objection?
Yes, Your Honor. At this point, we raise, Your Honor. The witness has already established that she's not familiar with this document. Opposing counsel further exploring this line of questioning is outside her scope of knowledge.
Your Honor,
Ms.
may I
Garcia?
continue?
Yes.
Yes, Your Honor. I'm not asking her to testify to the specifics of how this document was maintained or how it was, gotten from this specific medical center. However, I'm asking her what it says on screen. She can simply read it and say whether or not it's contradicting to her testimony.
So you're not asking her to confirm Exhibit 9, but rather a comparison to her own accounts.
Yes.
Okay, I think we can hear a bit of this, but if this doesn't seem to be the case, feel free to re-object.
Yes, Your Honor.
Understood. Now, ma'am, you claim that you were the one who were attacked.
Yes, ma'am. I was.
But this report right there, it says there was contusions to your right knuckle.
Yes, it does say that. It was self-defense. I was trying to break out of my ropes.
It never says that. It points to self-defense. Rather, it says it could indicate punching.
Right, ma'am. It says it could indicate, but I can tell you right now that I got those contusions because I was trying to break out of those ropes.
And just to confirm, these prosecutors or investigators never asked you how those contusions got to your knuckle.
No, ma'am. But I'm telling you right now that I was breaking out of my ropes and that I wasn't punching someone.
All right. Well, you're also telling us today that Miss Wölff, she wrote a threatening email to your family.
Yes, ma'am. She did.
I want to discuss whether those threats could be forged by painting a picture for the jury. Stating for the record, I'll now be screen sharing a visual aid. Ma'am, you see an email inbox?
Yes, I do.
Right here, I have a draft of an email, right?
Yes, ma'am.
We're going to go ahead and blow this up. And when we blow it up, you can see that these are the threats, and they match up with the threats you claimed Nova Wölff wrote.
Yes, they do.
I'm going to send this email to my co-counsel. And if we go to send, well, ma'am, you can see the user says, Nova Wölff, right?
Yes, ma'am, it does. But I wouldn't go through the
Objection, Your
trouble
Honor.
of all that.
Well, what's the
Your Honor.
objection?
403, more prejudicial than probative.
All right, could you elaborate a bit?
Yes, Your Honor. Opposing counsel displaying this email with an n.wolf with contents regarding this case is extremely more prejudicial than probative to the members of the jury, and given that this email was not in fact the email sent in today's case. Your Honor, it's our understanding that there was in fact an email sent in today's case, that's Exhibit 12B. If opposing counsel wants to reference such email, we'd be fine with that. But creating a
Miss May, what's prejudicial? It seems pretty clear that Miss Garcia is going to how easy it is to forge an email.
Yes, Your Honor. Going to creating a new email to the extent that replicating what this email says is more prejudicial than probative, given that this email, as we know, was sent by Miss Garcia and not by anyone else.
How is it prejudicial?
Your Honor, we don't see the name that this email is from. We just see that this could be from our opposing counsel, Miss Garcia.
A response?
Your Honor, this visual aid doesn't meet that high 403 bar for it to be substantially more prejudicial than probative. And Your Honor, if Miss May is really concerned about whether the jury will take this as an exhibit, we can stipulate right now that it's just a visual aid.
Miss May, do you have any arguments to, I mean, since that original email, I believe is already in evidence, to the authenticity of the account, maybe? Do you have evidence of that?
Yes, Your Honor. We simply don't know. Rather, this email is not from Nova Wölff, as we know, explained by Miss Garcia. If Miss Garcia wants to explore this line of questioning, she can do so using Exhibit 12B, and she can establish that that email wasn't in fact sent by Nova Wölff using that exhibit. It's simply unnecessary for her to show the members of the jury an outside email, given that we know it's from Miss Garcia, and that's more prejudicial than probative.
Okay,
Your Honor,
I understand. No need. I agree that the substantial bar isn't met here. Objections overruled.
Yes, Your Honor. Now, ma'am, right there it says the sender of this email was Nova Wölff.
Yes, ma'am, it does.
But ma'am, I'm not Investigator Wolf, am I?
No, you're not, ma'am.
So I just wrote a fake email and there was nothing stopping me.
Yes, ma'am.
I want to talk about whether or not the state asked you about that email. Because, ma'am, you can't testify that Nova Wölff actually ever wrote that email.
Well, ma'am, I think she did. Because she responded to me when I emailed her back. Sorry,
my apologies, ma'am. Continue. My apologies.
Oh, I finished.
Ma'am, you think, but you never saw her physically write that email.
No, ma'am.
Investigators never showed you any sort of forensic digital log of that email.
No, they didn't.
So let's talk about if you had a motive to write that email and frame her. Because Investigator Wolf has had tabs on your family for years.
She has. She sent us quite a few threats.
She's even made your job harder than it should have been.
She did.
She consistently kept track of your whereabouts.
Yes, ma'am, she did.
She was even working with the police to catch your crime family.
Yes, ma'am. Our crime family had many enemies.
Ma'am, you didn't just have many enemies. She was even helping the police catch you.
Yes, ma'am, she was.
And after she helped the police catch you, you went to jail for years.
We did.
Your Honor, at this time, I have no further questions.
All right. Ms. Ray, redirect?
Yes, Your Honor. May I proceed?
Please.
Ms. Ashlock, moments ago you were just asked how those contusions got on your knuckle. So how did they get on your knuckles?
Right, ma'am. I was tied up to a chair in Nova Wölff's basement. And since I was tied up, I had my hands in a rope, and I was trying to break out of those ropes. because I was held there against my will.
My apologies, ma'am, but I want to talk about that email we were just shown. Kat, can we get Exhibit 12A up? Your Honor, we ask for the court's indulgence as this document loads.
That's okay.
Your Honor, if necessary, our defense tech can bring up that exhibit.
Why don't we try that?
Yes, Your Honor.
We're actually looking for Exhibit 12A.
12A, Your Honor, I believe that might take a little bit more time to pull up.
Your Honor, that'll be perfectly fine. I'll have my co-counsel.
Oh, there you go.
Oh, great. Ma'am, looking at this exhibit, what does that exhibit say?
It says the wolf, and it has a bunch of contact information for Nova.
And looking down at that email, is that the email that was sending you threats?
Yes, ma'am, it was.
And so who did you believe that those emails were coming from?
Nova Wölff.
All right, ma'am, Tech, we can get the exhibit down. And so, Ms. Ashlock, would you ever frame Miss Wölff for your kidnapping?
No, ma'am, I'm trying to become better. I would never frame someone for anything. Not anymore.
Thank you, Ms. Ashlock, for your time today. Your Honor, at this point, I have no further questions.
All right. I don't think Miss Garcia has time for redirect. Miss May, anything else from the prosecution, or do you rest your case in chief?
Nothing further, Your Honor. May this witness be excused?
Absolutely. Thank you so much.
Yes, Your Honor, and with that, the prosecution rests.
All right. Let's take a 3-minute break. I'm going to try to get my Wi-Fi fixed, and I'll see you guys, about 3 minutes.
At this time, the defense calls Charlene Reeves to the stand. May I proceed?
Please.
Good evening.
Hello.
Please introduce yourself to the members of the jury.
Hi everybody. My name is Charlene Reeves.
Miss Reeves, where are you from?
A long time ago, I grew up in Tilly, but I like to say that my real home is New York City.
Why do you say that?
Well, I worked as a taxi driver there. You could say I picked up more playbills than I did passengers.
Why do you say that?
Well, the best part about living in the Big Apple is getting to see all the shows on Broadway. Nowadays, with all these gray hairs, watching musicals at the local high school with my neighbor is much more my speed.
Miss Reeves, can you tell us who your neighbor is?
Nova Wölff. Oh, goodness. Her family and I were cut from that same musical loving cloth.
Now, switching gears, I want to ask whether or not you understand why you're here today.
Oh, you bet I do. I was there the night Nova was attacked by a criminal, and I'm here to talk about it.
Objection, Your Honor. 404 character evidence as to depiction criminal.
Response?
Your Honor, this isn't character evidence as we aren't intending to use it for propensity purposes. Rather, under 404B2, her intent as to what Miss Wölff was going to be, or rather, what Miss Ashlock was going to be doing.
Response, if I may, Your Honor.
You may.
The establishment of the word criminal is not necessary in order for opposing counsel to establish intent. We simply ask the witness to omit any mentions of the word criminal, given that it is character evidence against Miss Ashlock.
Your Honor may be heard.
You may.
As the proponent of this evidence, we aren't using it for propensity purposes. If we were, that would mean it was character evidence. But since we aren't, rather it's going to intent. And if I may proffer,
Go ahead.
we have a good faith basis to believe Miss Reeves will soon be breaking down how she knew that Miss Ashlock had an intent to harm Miss Wölff because of prior criminal acts.
Response by me, Your Honor?
No, I don't think it's 404, but I do agree with Miss May here. I think unless I hear more testimony, let's have the witness refrain from using the word criminal, please.
Yes, Your Honor.
Yes, Your Honor.
Now, you were mentioning that you were there the night Investigator Wölff was attacked. Is that why you're here to testify?
Yes, I'm here to testify because that night Nova was attacked.
Well, let's discuss whether Miss Ashlock had a motive to harm her. To your knowledge, do you know Miss Wölff's occupation?
When Miss Wölff isn't disciplining her kiddos, I help babysit them while she disciplines all these different criminals as a private investigator.
Do you ever talk about her work with you?
You could say that us ladies have the gift of the gab. Over, homemade cookies, afternoon tea. She always chit-chats about her town and even this family. They're called the Ashlocks.
Miss Reeves, when you were talking with her, did she ever say she wanted to kidnap the killer, Ashlock?
Oh, goodness, no.
What did she say?
She told me she's been helping the police catch the Ashlocks for years. She reports and gives tips of all kinds of this activity, and she even helped put some of the Ashlocks behind bars.
Well, let's talk about if she stopped Miss Ashlock from committing a crime. What were you doing the evening of March 12th?
Let's see. I was at our senior center, practicing for our production of Annie. Just think less hard knock lives and a lot more hard knock hips. I was really happy that day I was cast as Annie. And I think he's a police officer. He just looks like one, and I think he is. He was cast as Daddy Warbucks, and after that, I was so happy, I started heading home around 10:30.
Stating for the record, we'll now be screen sharing a visual aid of events. So after 10:30 and after your very eventful night, did anything else happen out of the ordinary?
At first, I was just humming show tunes to myself. But then I turned this corner and I realized that someone I didn't recognize at first was walking towards mine and Nova's buildings.
Miss Reeves, what did you do?
I didn't know why that person was there. It made me scared to think someone I couldn't see was so close to my neighbors and I. Thankfully, I wasn't too far from Investigator Wölff's house to ask for help, so I was frantically knocking on her door.
Did she answer?
Yes, she opened the door. I told her what was wrong, and she told me to go back inside and she would take care of it for me.
To your knowledge, did she take care of it for you?
I had believed so. I mean, just a few minutes later, I heard someone belt out at the top of their lungs the name Ashlock.
What happened next?
Then I peeked out my window and I recognized the person as Cotter Ashlock near the door. She had this kind of short black hair with these bangs, and she was wearing this dark colored jacket.
I want to make things clear and talk about whether or not you saw Investigator Wölff kidnap her. Did it appear that she was threatening Miss Ashlock?
Not from what I saw. You know, she wasn't holding a weapon or gloves or trying to tie her down. I just saw Ashlock walking freely out the door.
Did you see her physically blocking Miss Ashlock from leaving the house?
No, she wasn't standing in front of the door or anything of that sort.
What did you see?
I saw Nova say something, and instead of running away, Ashlock ran right back into the house.
How did Investigator Wölff react?
Well, after Ashlock ran back in, I heard a pained yell from Nova saying, "You have a knife?"
What else did you hear, Miss Reeves?
The next thing I heard was Nova commanding her real sternly to stop and let go.
And that night, after hearing the words, "You have a knife," and "stop, let go," what happened?
I heard police sirens. Let me tell you, it was music to my ears, even better than my favorite Broadway show.
Why?
That told me that the police were coming and the scariest night of my life was coming to an end, and Nova and her little kiddos would all be safe.
Thank you, Miss Reeves. I appreciate your time. Your Honor, at this time, I have no further questions.
Cross-exam, please.
Yes, Your Honor. May I proceed?
Please.
Yes, Your Honor. Good evening, Miss Reeves.
Hello, darling.
Now let's get this straight. You like theater, don't you?
I love theater.
You like acting in Broadway.
Yes.
Now, one of those shows you watched was Hamilton.
Yes, I watch it quite a lot.
And you'd agree with me that Hamilton had good friends.
Hamilton had great friends.
Now, just like Hamilton had great friends, you were actually good friends with the defendant.
Yes.
In fact, you'd even go as far to say that the defendant was like your grandkid.
Yes, I would say exactly that.
So let's get this straight. You would say that you're testifying in court today for a good friend that you might call your grandkid.
Yes, 'cause I'm testifying based on what I saw and heard that night. Sorry, I don't know if that's the right way to put it. I never was a lawyer myself.
That's perfectly all right, ma'am. I just want to get this straight. Yes or no, you're testifying for someone that you might call your grandkid.
Yes.
And for you, it's kind of novel to be involved in your own Broadway show, right?
You could say that. That sounds about right.
You would say that.
I'm sorry?
You would say that, ma'am. It's kind of novel.
Yes.
And being good friends with the defendant, you learned that she'd moved to your town for revenge, right?
I did. She told me about her friend, her best friend, got poisoned and killed, and yes, that's what I know.
Exactly. The defendant's best friend was killed by the Ashlock family.
Yes.
And so she wanted revenge against the Ashlock family.
Objection as to speculation.
Your Honor, response?
Mm-hmm.
Your Honor, if the witness doesn't know, she can say she doesn't know. It's cross-examination.
So overruled.
Yes, Your Honor.
Ms. Reeves, I'm going to ask my question one more time. Ms. The defendant wanted revenge against the Ashlock family.
Yes, that's what I understood it to be.
And from what you understood, it was because the Ashlock family killed her best friend.
Yes, it seemed kind of like a justice thing, but that's what she told me.
You'd say it's a justice thing because the defendant would talk a lot about the Ashlock, am I right?
Yes, it was part of her job.
Well, her eyes would light up whenever she did.
Yes, I think she was excited about her job. You know, if I was an actress on the real Broadway stage, let me tell you, I would never stop talking about it.
Well, backing up for a moment, you'd say that she'd get excited about talking about reporting information about the Ashlocks to the police.
Yes, she seemed excited about her job.
She'd get excited talking about how closely she works with the police to bring justice.
Yes, I think she has a strong sense of justice. You know, she's a person who believes for what's fair and just.
I'm not asking for what Miss Wölff believes. I'm simply asking if she's getting excited. And she would.
Yes.
But despite her getting excited for all of this, you never found that she got excited about anyone other than the Ashlocks.
I wouldn't say as excited.
I want to move on and talk about what happened on the night of March 11th. Is that okay?
That's perfectly fine. That's why I'm here, ma'am.
All right, so on that night you were walking home.
Yes, walking home from rehearsal.
You felt like someone was following you.
Yes, I could see someone, but I couldn't make out who it was. It was too dark.
Is it your sworn testimony today that you could see who was following you?
No, I couldn't see them. It was too dark.
Exactly, you couldn't see their face.
No.
You didn't hear their voice.
No.
And while you were being followed, you didn't turn back to look at them at any point, did you?
No, I didn't.
And once you got back home, you didn't look outside at any point to see who it was?
Not once I'd gotten home. Nova said she would take care of it for me, so I didn't really check to see.
So you can't be certain that on that day it was Miss Ashlock that was following you.
Following me? No. But I did see her when she ran out of Nova's house.
I'm not asking about when she ran out of Nova's house. I'm asking about following you. And you don't know if that was Miss Ashlock.
I can't tell you for sure, but she was in the neighborhood right after that.
That sounds like a yes to my question.
Yes.
And you also told us that you heard a struggle.
Yes, I heard a struggle from Nova's house.
But you can't tell us who started that.
No, I wasn't there.
You can't tell us what objects were inside that house because you weren't there.
That's exactly right, ma'am. I wasn't in the room where it happened.
And so, Miss Reeves, you can't tell us anything about what happened inside that house because you weren't in the house when it happened.
Objection as to asked and answered.
Sustained.
Ma'am, you can only testify as to the sounds you heard.
Yes, not just the sounds, but also the words I heard. But that's a yes.
Thank you, ma'am, for your time today. Your Honor, I have no further questions.
Thank you, Miss May. Redirect?
No, Your Honor, may Miss Reeves get back to her Broadway shows.
Yes, please. Thank you so much. Defense, you may call your next witness.
Yes, Your Honor. We call our client Investigator Nova Wölff. Good morning.
Good morning, ma'am.
Please introduce yourself to the members of our jury.
I'm Private Investigator Nova Wölff.
Investigator
Sorry.
Wölff.
One moment. Do we still have Judge Lampert? Just checking if he's still here. Michael? Sorry about that. Okay. Go ahead. My apologies.
Investigator Wölff, do you understand you have a constitutional right not to testify?
I do. I've been told that many times. But look, I need to set the record straight today.
I understand that, ma'am, but before we talk about what the state's been saying, can you tell the members of the jury a little bit more about yourself?
Sure. I'm a private investigator, PI, and when I'm not in the office, I'm probably spending time with my two kids. I've got a 13-year-old and a 7-year-old at home.
How'd you get into being a PI?
My papa, he used to tell me that there were three kinds of people in this world. You've got the bullies, the bullied, and then the protectors. And while I wasn't quite big enough to bully, and I was too stubborn to be bullied, I just wanted to protect people.
How are you qualified for your job, ma'am?
I love to say that my first real training was growing up with three older brothers. But professionally, I earned my credentials in criminal justice. I completed 6,000 hours of compensative investigation experience, and then I obtained my private investigator's license. It's been 22 years now of trying my best to protect my community.
Is there anyone you protect your community from?
Yes, there's this family in my area. They're better known as a crime syndicate. They're infamous for all sorts of crimes. Homicide, extortion, poisoning, things like that.
Do you know them personally?
I do. They were the ones who poisoned my friend Mark 5 years ago.
On that note, ma'am, I'd like to talk about what the state's been saying today. Have you been here all trial?
I have.
Did you hear Miss May ask Mrs. Reeves whether or not you wanted revenge?
I did hear that.
Ma'am, did you want revenge by kidnapping someone?
No. Look, I wanted justice, but not like this. Mark always told me that, when people are safe, that's when our jobs are done. I wouldn't kidnap for someone for personal vengeance. That just isn't what I do, and not how I would honor a loved one.
How did you want to honor that loved one?
Well, by protecting as many people as possible, making sure what happened to Mark never happens to another person under my watch. That's my job. And That's why I performed a citizen's arrest on Cotter Ashlock, to stop his crimes.
Taking a step back, ma'am, did you hear Miss May say in opening statements about the detention and the disregard?
I heard that, yes.
I'd like to walk down those two things if that's okay with you, ma'am, starting with this so-called detention. Did you detain Cotter Ashlock to get revenge?
Absolutely not.
Did you detain Cotter Ashlock to catch a killer?
No.
Why did you detain her?
To perform a citizen's arrest on a known criminal who was
Objection.
violating her.
Improper expert opinion under Rule 702, if I may be heard.
702. You may.
Yes, Your Honor. Right now, it's established that the defendant is just a lay witness, and having her testify that I conducted a citizen's arrest presumes more than she can testify. Because, Your Honor, as you heard from opening statement, citizen's arrest does have several prongs that have to be met. It is the whole reason why we are here in court today. It is improper for her to testify that, yes, I did, to my knowledge, conduct a citizen's arrest.
Response, Your Honor.
Yes, please.
Your Honor, pursuant to Rule 704A, an objection on an ultimate issue, or rather, an opinion on an ultimate issue, isn't automatically objectionable just because it embraces that ultimate issue. Your Honor, this isn't going into expert territory. It's fully in this witness's capabilities and her knowledge as the defendant in today's case to testify as to what she did.
Response, Your Honor?
Mhm.
We still have issues with the word choice this defendant used, because she didn't just say, I think I did a citizen's arrest to the best of my knowledge. She said, I did do a citizen's arrest. And considering how that is the whole point why we are in court today, it is absolutely necessary that she does not get this onto the record.
Response.
Right? No, that's okay. I think a private investigator who's also the defendant of this case, it's okay to phrase that wording as this. Objections overruled.
Yes, Your Honor.
Your Honor. Ma'am, a moment ago, did you see a timeline up on the screen?
I did.
I'd like to show you that timeline again, ma'am, and we can fill in the gaps for the members of the jury. Stating for the record, Your Honor, we'll be screen sharing that timeline again.
Mm-hmm.
My apologies, Your Honor. It seems we're sorting out some tech difficulties. Can we pause time and...
There you have it.
Yes, Your Honor. Can you break down the series of events for the detention from your perspective?
Sure. A little after 10:30, I just tucked my kids in. I remember my neighbor, Miss Reeves, she knocked on my door and she said that someone was following her in our neighborhood.
What did you do?
I went outside to de-escalate the situation, and I saw Cotter Ashlock.
How did you react?
Well, first I was shocked, and then I was worried. For my neighborhood, I confronted Ashlock and I told her to leave my town.
What did she do?
She was shouting at me. She reached into the left side of her jacket and she pulled out this huge knife and she lunged at me towards me with it.
What did you do after that?
I disarmed her. I kicked the knife out of her hands. It fell on the sidewalk. I restrained her and I took her to my basement because having her on the streets would be a disturbance for my entire neighborhood. I thought taking her to my basement, separate from my house, I could keep an eye on her.
Did you call the police at that time?
I couldn't because she untied her hands later. She was throwing things around, banging on the wall. It wasn't safe to call the police while this criminal was causing trouble in my house.
What did you do?
I talked to her. We had a brief conversation.
Stating for the record, we'll be screen sharing Exhibit 2, a recording of that conversation. Ma'am, the state alleges you held Cotter Ashlock in your basement against her will. Is that true?
No. It was safer for me to wait until she'd left my house before I called the police. I even told her, "You're no one's prisoner," which was true because she left momentarily after. She literally walked out of my basement and I followed her to my doorway.
Did you see her do anything as she walked out of your basement?
She walked to my door, walked to the sidewalk we were at earlier. She bent over and she picked something up.
Did you see what she picked up?
It was the knife from earlier. And she just charged back at me towards my house with that huge knife. And, well, that's when I screamed, "You have a knife?" And stop, let go.
I'd like to talk about what happened in between you screaming those words and the police arriving. Do you remember the state saying you disregarded the police?
I remember.
Ma'am, let's get this clear. Were you physically able to call the police?
I couldn't. I would have if I was able to. But Ashlock was causing chaos in my basement, threatening me with a knife. You can't just pull out your phone and dial 911 while being lunged at. So I couldn't call the police.
Investigator Wolf, I want to make some things very clear for the members of the jury. Did you detain for any reason other than a citizen's arrest?
No. I was just trying to protect my community, my kids, my neighbors.
Did you kidnap to catch a killer?
No. Look, when she tried to attack me, when she broke that parole, I exercised my right as a citizen. I wasn't trying to do anything else but perform a citizen's arrest.
Thank you, Investigator Wolf. No further questions.
Cross-exam, please.
Yes, Your Honor. Good evening, ma'am.
Good evening.
Let's see if you wanted to catch a killer. Because you hate the Ashlock family.
I really did after what they did to my friend Mark.
Right, a former member killed your best friend.
That's right.
You've wanted revenge against that killer for years.
Revenge, but not like this. I never wanted to hurt them. I just wanted justice.
You wanted justice, but the problem was that killer went into witness protection.
One of the killers, yes.
And so since then, you started tracking down that Ashlock crime family.
That's right.
Hoping they could point you in the direction of the friend's killer.
No, that's not why I've been trying to help the police capture the Ashlocks. That's a no.
Man, but the whole reason you moved to this community was because of the Ashlocks.
Yes, but to help jail them, not trace them down, stalk them, and kill them. No.
Okay, well, let's turn gears and see if you went outside of the law. First, let's set the scene. March 11th, 2025, you detained Cotter Ashlock.
That's right.
You are in your basement.
Yes.
Ashlock is tied up to the chair with rope.
Initially, yes.
Now, you had a timeline brought up. To Your Honor, for the record, the state will now be screen sharing a copy of the defense's demonstrative. Now, ma'am, you claim that Cotter Ashlock came out with you with a knife.
That's right.
That's why you restrained her.
Yes.
That's why you detained her.
Not quite. I detained her because she was breaking parole.
All right, but you also restrained her because she was waving a knife at you.
Absolutely, yes.
But this is the first time we're hearing about that knife from you.
I guess so.
You've had multiple depositions with the police.
I wasn't asked about the knife, but I did have a few depositions.
You had plenty of opportunities to talk with the officers.
Ma'am, in my line of work, I know to only answer the questions I was asked, and I had no opportunity to bring this up. But no, I didn't talk about it to the officers.
Ma'am, in those depositions, you found it important enough to correct Officer Capolino's grammar, didn't you?
Sure.
You didn't find it important enough to tell them you acted in self-defense?
Ma'am, I'm telling you right now, I acted in self-defense. I didn't think I have to bring up every detail from that night to the police officers.
That's a no. You didn't tell the police about that knife.
I didn't.
That's a no. You didn't tell them you were threatened by Cotter Ashlock, and that is why you detained her.
I don't remember saying that to them, no.
Right, what you tell the police instead is, Cotter Ashlock is trespassing on my property. Get here as soon as you can.
Right.
And now, a moment ago, you also claim you told Cotter Ashlock he was free to leave whenever she wanted to.
That's right, she was.
Now, I want to make sure I'm getting your story straight, because you're a detective who has been hunting down the Ashlocks for years.
I've been trying to help catch them legally for years.
And you come across Cotter Ashlock and she chooses to come down to your basement?
No, I restrained Cotter Ashlock when she pulled a knife on me, and then I took her to my basement.
You restrained her so she wasn't free to leave whenever she wanted.
That's right. But then, as she was in my basement, I could hear crashing sounds, and when I went down again, she'd untied herself.
So she wasn't free to leave whenever she wanted, yes or no?
She was. Once the knife was gone, once I had a conversation with her, I told her you could leave whenever you wanted, but I would still call the police.
And she chose to stay in your basement.
She actually left. But then
You're
when
saying
she did leave my basement. She was untied at that point. But when she left, she pulled the knife out again and came back charging at me. I had to restrain her once again.
Ma'am, it seems like your story's getting really complicated. She pulls out a knife, you restrain her, she gets free.
Your Honor, attorney testifying.
Sustained.
Motion to
It's
strike.
stricken.
Yes, Your Honor.
Ma'am, so the truth is, you let her go when she leaves.
That's right. After I said you're no one's prisoner, I let her leave.
Then she comes back right at you.
With the knife, yes.
All right then. And finally, I want to talk about something you left out on this timeline. Because, ma'am, you also questioned Miss Ashlock.
I had a couple of questions for her, sure.
Yeah, you had a couple of questions about the Ashlock family.
All I asked her about was, why are you in Corleone? Why are you in my town?
You asked her also about Jay Kuang.
No, I didn't.
Ma'am, you're saying you didn't ask her about Jay Kuang?
No.
You heard Cotter Ashlock testify today. That's exactly what you said.
Cotter Ashlock is not telling the truth because I never asked her about Jay Kuang. That's not why I arrested her.
All right, but you still did ask questions about the Ashlock family.
All I asked her about was what she was doing in my town. That was it.
You didn't ask her about why she was waving a knife at you.
That was up for the police to figure out. No, I didn't ask her.
But it was up for you. It was up to you to ask her why she was in your town?
Absolutely. I witnessed her breaking parole.
Thank you, Your Honor. We have nothing further.
I don't think there's time for redirect, correct? You're muted, Mister.
Yes, Your Honor. We'll let Investigator Wolf's words stand for themselves. With that, we
All right.
rest our case in chief. We're ready to go into closings.
Thank you so much. Again, let's take a very short break. 2 minutes, give or take, okay?
Yes, Your Honor. She kidnapped to catch a killer. Where are the Ashlocks. That's what the defendant asked Cotter Ashlock again and again, holding a knife, threatening her for information. Because she spent years tracking down that crime family, and she kept asking those questions because she didn't kidnap for the safety of her community. She kidnapped to catch a killer. Now, the defense today tried to spin a story of gold, came up with a fancy shining term of citizen's arrest, but all that is gold does not glitter. And their case is no exception. Vigilantes are illegal. Whether it is capturing a criminal to stop a crime, in the court of law, we have to hold them accountable. We showed you a case of silver today that might not glitter as brightly, but remained constant and left you with zero doubts that the defendant kidnapped to catch her friend's killer. That is why today, as the state of Chile, we are charging the defendant for unlawful imprisonment, and that does mean we have a burden to prove beyond a reasonable doubt that Nova Wölff committed these crimes on March 11th, 2025. To meet this burden, there are two things we have to prove to you today. First, the defendant, a civilian, interfered with an ongoing police investigation, so second, they could restrain and kidnap Cotter Ashlock. They disregarded the police to detain their enemy. So first, she disregarded the police. You heard from the officer today that he warned the defendant this wasn't her case, and she should not get involved. But the defendant just wouldn't listen. She continued to investigate, and when she came upon Cotter Ashlock, she took the law into her own hands and kidnapped her. Members of the jury, citizens kidnapping a police suspect is against the law. She interfered with the police's active investigation. So second, Miss Ashlock was detained. Because if there's one thing every single witness but the defendant agreed on today, it was that the defendant wanted revenge against the Ashlock family. And Ashlock killed her best friend, and she was willing to do anything to bring them to justice. Now, members of the jury, don't take it from me. Take it from the evidence that we showed you today, where Cotter Ashlock says, I want you to untie me before I spill a single word. Lines where Cotter Ashlock says, I want you to. Lines where she was being interrogated again and again about the location of Jay Kuang, her friend's killer. She kidnapped to catch that killer. Members of the jury, it is clear beyond a reasonable doubt that the defendant interfered with the police so she could unlawfully restrain her enemy. We met our burden, but we're not the only ones who have one today. Because by choosing to pursue a citizen's arrest, the defense has taken it upon themselves to prove something called an affirmative defense. We're going to focus on the most important prong of the affirmative defense they have to prove. Nova Wölff contacted the police at a reasonable time. Members of the jury, the truth is, she didn't. Because instead you learn that she waited. The defendant waited to ask questions. Now, the defendant might have claimed today, I was just asking about the Ashlocks and why she was here. Regardless, members of the jury, that is still against the law. Citizens are not allowed to interrogate or ask questions to the person they detain. That is the job of the police, and that is against the law. Citizens have to call immediately because it is law enforcement who must do the jobs. Now, the defense today, they also did bring up 3 points: crime, capture, contract. We do agree with most of it. There was a crime, there was a capture, there was a contact. But the thing is, the timing is what makes this case matter. And there was too much time between the defendant restraining Cotter Ashlock and calling the police. Now, for just a moment, members of the jury, I want you to think about the most important moment in this trial. And that was on the cross-examination of the defendant when we learned about all her inconsistencies. Now, there are 2 people who can tell us exactly what happened in that basement: Cotter Ashlock and the defendant. But Nova Wölff lied again and again. First, she told you that Miss Ashlock was free to leave, and then she wasn't free, and then she was free again, and then she realized that it contradicts everything about her story and what her attorney said, and suddenly we don't know what's going on. And then she talked so much about a knife in court. But when asked why she never told it to the police, she said it wasn't important. She thought it was more important to correct Officer Capolino's grammar. It's because she kidnapped to catch a killer. Find the defendant guilty. Thank you.
Thank you, Ms. Law. Closing arguments for the defense, please.
Yes, Your Honor. She captured a criminal to stop a crime. Miss Lowe just told you Investigator Wölff kidnapped to catch a killer. But today you learn Investigator Wölff didn't ask where are the Ashlocks. Instead, it's us who are left asking where is the evidence. Because members of the jury, when Miss Lowe decided to come up here, ask you to turn Investigator Wölff from a mother and a protector of her city into a convicted felon, into a kidnapper. Members of the jury, she's taken on the most difficult burden of any prosecutor in any courtroom for any crime. It's called proof beyond a reasonable doubt. And what that means is that at the end of today's trial, if you have one reasonable question, one reasonable concern that her story might not be straight, Investigator Wölff isn't guilty. But folks, when Miss Garcia and we saw these prosecutors charging Investigator Wölff with unlawful imprisonment. We knew that wasn't the case. We knew that she didn't disregard and detain like Miss Lowe told you, which is why we've taken on an affirmative defense. We had to prove to you three things. She witnessed a crime, she used reasonable force, and she contacted the police within reasonable time. We need to prove these to you by a preponderance of the evidence, being more likely than not. And folks, we've proven that to you today through three facts. The crime, the capture, the contact. So first, the crime. Did Investigator Wölff witness a crime or breach of peace? Today you learned she witnessed both. Not only did she see a criminal violating her parole, walking down the streets of a community she wasn't legally supposed to be in, but she was also assaulted. Assaulted by that criminal, assaulted by Cotter Ashlock. But you don't just have to take that from me. You can take it from the evidence you saw with the police investigator. Because when a forensic report exists, but they choose not to show you, when a medical report exists, but they choose not to bring that up, members of the jury, that leaves us asking, where is the evidence? And why isn't the state showing that to us? Today you learned the answer to that question is because that doesn't help their case. It's because the evidence doesn't prove to you Investigator Wölff kidnapped to catch a killer. Proves to you she did the opposite. Proves to you that she captured a criminal to stop a crime. So second, the capture. Did Investigator Wölff use reasonable force? Today you learned the answer is yes. Because today you saw a medical report. And when you saw that medical report, not only did you see no signs of injuries inflicted on Cotter Ashlock, but you also saw signs that Investigator Wölff was the one being assaulted. And today you learned not only was she assaulted, she was held at knife point. And when she was doing that, the law doesn't require her to be as gentle as possible. The law doesn't require her to wait until she's bleeding out on the street to make a move. The law requires what's reasonable. And you learned today what was reasonable is exactly what Investigator Wölff did. But lastly, you learn about the contact. Did Investigator Wölff contact the police within reasonable time? A moment ago, Miss Lowe told you this is the most important thing to focus on. If that's the case, members of the jury, let's talk about it. Because you learned today, reasonable time, that doesn't mean immediately. That doesn't mean Investigator Wölff had to dial 911 while a knife was held to her throat. That doesn't mean she had to call the police when a criminal was threatening her safety. That means she had to call the police as soon as she could, and you learned today she did that. But let's take a step back. If Investigator Wölff was truly this vengeful person who wanted revenge so much, why did she call the police? Members of the jury, the police didn't even know where Cotter Ashlock was. You learned today on the cross-examination of their officer, for a week straight, they just couldn't figure out where she was. Members of the jury, Investigator Wölff, she wasn't vengeful like they want you to believe. And yet, you heard in the first half of trial, they kept going on about these threats. Until you saw this fake email. A fake email that proves to you just how likely it is to fake those threats. Once that happened, the state never brought up those threats again. Why, members of the jury? Because they know those threats that they want you to believe is motive, members of the jury, that isn't true. But lastly, I'd like to talk about something Miss Luo mentioned a moment ago, the disregard. Today you learned it wasn't Investigator Wölff who disregarded the law, it was their own police officer who disregarded the evidence. Kept saying on cross-examination, that's strange. Members of the jury, we agreed. It's strange that a police investigator sees evidence and just ignores it. It's strange that a police officer sees signs of assault and turns a blind eye. And members of the jury, it's strange that at the end of today's trial, we're still asking the same question. Where is the evidence? And when Miss Luo can't prove that, she's failed her burden. Find Investigator Wölff not guilty. I appreciate your time.
Thank you, Ms. Liu. 47 seconds for rebuttal, correct?
Yes, Your Honor.
Would you like to?
Yes.
All right.
Miss Liu asked, where is the evidence? We showed you so much of it today. In fact, we even took it from the defendant's own words when she admitted on cross-examination that she asked Cotter Ashlock questions about the Ashlock family. Now, members of the jury, a citizen's arrest means you have to call the police immediately afterwards. It is safe. That moment, Cotter Ashlock was tied up. She was restrained. But instead of calling the police like she should have done, which would abide with the law, the defendant instead chooses to get revenge. Because this whole reason, the reason why we're here in court today, is because she wanted revenge against her best friend's killer. She didn't want justice. Now, truly, the defendant's word today doesn't even mean a lot, because inconsistency after inconsistency, she talks about the knife for the first time in court. Her story about letting Ashlock go keeps changing. Members of the jury, that is an unreliable defendant. And you gotta ask yourself, why is she lying? That's because she kidnapped to catch a killer. Find her guilty. Thank you.
We are back off the record, but on recording. Let's begin with Judge William Wu for any comments for the teams.
Yeah, I think overall it was a really, really incredible round. I really enjoyed it. I think all the witnesses were great, and the attorneys all did a very good job arguing. My only feedback would probably be that the attorneys could make objections a bit more strategically, and when responding, be a little bit more responsive to each other's arguments. And witnesses, I think everyone on direct was very polished, very well done. But on cross-examinations, probably could work on a little bit on when to fight and when to not, because there's, is a balance about evasiveness. But overall, a really, really good round.
Judge Michael Lampert.
I think everybody did a great job, super high level. I think that the prosecution had more to work with here. And I think actually the charges were a little bit light for the offense. I was wondering why it wasn't second degree or first degree kidnapping. Actually, it was at least, I thought it was at least second degree kidnapping. The witnesses were terrific and really were able to put out kind of emotionally where they're at. Cotter and Private Inspector Wölff really were able to kind of emotionally connect, as was Ms. Reeves, who was a very good character witness. But it was a tough case for the defense. But this is maybe the highest round, the best round I've ever seen, actually.
The best round he's ever seen in about 16 years of mock. Honorable Judge Wong.
Thank you guys so much for this amazing round. I was having a word with William just now, and both of us thinks that you guys would beat a lot of AMTA teams, collegiate mock trial that is. My only feedback is, different judges have different perspectives, but I'm just generally not a fan of mock sense. And yeah, but that really depends on the person. So, whatever your coach tells you to do. And other than that, it was just overall really, really good. I love the email. I thought whatever Lily did with her forehead is, I don't comprehend what happened there, but it was amazing. And congratulations to all of you.
Time for the announcement. We're going to begin with MVP witnesses. As befits a good final round, there was no way to break the tie for MVP witness because there were 3 judges with 3 different votes. Sharing in the MVP witness in the final round, from the prosecution, 1 vote to Tobin Hill. The second vote to the prosecution, Kayl Hua. Third vote to the defense, Ms. Lily Kizirian. Congratulations, all co-MVPs. There was a MVP attorney on a 2-to-1 decision because its finals will announce the other recipient. The runner-up receiving 1 vote from the prosecution, Ms. Anya. And your MVP in finals receiving 2 votes from the defense, Ms. Christiana Garcia. This takes us to the final results. Now, for the recording, for the record, one of these teams took first place at the first IMT contest of the year. The second team took first place at the second IMT contest of the year. And here they are meeting in finals. The first ballot came in. It was a +9 for the defense. The next ballot came in, and it was a +8 for the prosecution. This takes us to the final result, which, perhaps predictably, was decided by 1 point on the last ballot. So, congratulations to both teams. Very well fought. But the champion of the largest IMT contest yet by that single point is the defense. Well done to both teams. Fantastic work. And we will see you in May for the second IMT alumni contest.